welcome to the second episode of CML Talks. I am Swam Sambar Mohanty, the coordinator at Center for Maritime Law. Through CML Talks, we aim to educate and make more people aware about maritime law, which is a less explored and less known area. In today's podcast, we have with us Apurva Mehta Pohonerkar. She is a practicing advocate at Bombay High Court. Ma'am is a partner at ANB Legal. We'll start the podcast in 3, 2, 1, go.
Good evening, ma'am. Thank you for taking out time to be here in CML Talks. We're privileged to have you here.
Thank you so much. Thank you for inviting me.
Ma'am, what are the different kinds of disputes that you come across in your practice as a maritime lawyer?
As a maritime lawyer in India, our practice is actually mostly litigation oriented. And by litigation, I also mean arbitration. So most of the maritime lawyers in India, you would see, mostly in courts and also doing related advisory. And the kinds of claims that we come across are typically cargo-related claims. So, where there is damage to cargo, there may be a shortfall in cargo. The specification is not correct. So, there may be claims related to that. You will see claims related to charter parties. So your voyage charters, your disputes under time charters, you may have bunker related issues. Then there are also personal injury and death related claims. You can also have towage, salvage, marine insurance related issues. Little unknown, but maritime lawyers also do a bit of practice under the Customs Act. There are issues with respect to port, where there is, say, damage done to port property, or there may be a dispute relating to the tariff that is imposed by the port. You may also have ship sale purchase related work. So that could also include advisory or drafting of the sale purchase agreements for vessels or shipbuilding contracts. Then there is also ship finance work that is done. These are, I think, broadly the practice areas that any maritime lawyer would be undertaking in India.
So, which courts or forums are typically preferred by these parties, such disputes?
Okay. So there are claims called maritime claims, which are agitated, which are, there are a certain number of claims which are enumerated in the Maritime, in the Admiralty Jurisdiction and Settlement of Claims Act. So in that, when you are enforcing one of those claims, you go before the Admiralty Jurisdiction of the High Courts. So all the coastal states have High Courts before whom you agitate these matters. There are also a large number of matters which are before arbitration. So those matters would essentially be virtue of a contract between the parties. There can also be cases that are before the magistrates court under the Merchant Shipping Act or the other acts. You would also, we also at times have to appear before the NCLT, because finally all these companies are regular companies that are incorporated in India. So when you have issues with respect to, say, an operational debt, or if you want to get a company wound up, then that is when you would go before the National Company Law Tribunal. A lot of disputes are also agitated, particularly marine insurance disputes are agitated before the Consumer Forum. So you would also, in your practice, you may also happen to appear before the Consumer Forum.
As you said that you deal with a lot of disputes, and one of the disputes is a dispute related to port matters. What are the kind of cases come in the purview of disputes related to port matters?
Okay. So port matters, actually, they are a subset of tariff disputes. So you can essentially have two kinds of disputes when it comes to port. One is that, and I'm only talking about the tariff here. So under tariff, what happens is that you are either challenging the tariff itself that has been framed, or you are challenging the interpretation of the tariff. So for the major, and I will limit my answers to the major port trust. So the tariff for major port trusts is framed by and approved by an authority called TAMP as of now, which is the Tariff Authority for Major Ports. It will very soon be replaced with the adjudicatory board under the Major Port Authorities Act. So they frame the scale of rates, and the scale of rates are approved by TAM. So the issues could be either with respect to the tariff which is already framed. So port users or parties may have an issue with the rates itself. So then that is where the constitutional validity of the act itself, of the scale of rates, get challenged. And second is the interpretation of the scale of rates. So this dispute is primarily between the port user and the port, where say a certain rate is framed, but a party may not, and the port has interpreted that rule in a certain way, but the port user may not agree to that interpretation. So that is the disputes that you would see in respect of tariffs under the with ports.
Ma'am, what is the role of P&I clubs in the maritime industry? Like, how do they differ from insurance providers?
Okay, good question. Actually, this will be interesting for all the future maritime lawyers. So, P&I clubs, that is the protection and indemnity clubs, they are the backbone of the entire maritime industry, because they are different from your regular insurers. A P&I club is actually a group of historically, where ship owners came together and insured each other. So that is called a mutual insurance. That is why you will find that the insured, that is the ship owner, is never called the insured. They're called the members, because you're insuring each other mutually. So with the P&I club, what they essentially do is they insure your liabilities, your third-party claims that may arise. So things that are not covered under your hull and machinery insurance. Typically, these aspects are taken up by P&I clubs. Another very important aspect that is looked after by P&I clubs is your crew claims. So looking after the welfare of the crew, even under the Maritime Labour Convention, a certificate from the mostly from the club is required. It's the state party who delegates it. So the clubs here, their certificate is required to say that that if there is any disputes with respect to the wages of the crew members, that would be taken up. That would be taken care of by the club to the extent of 2 months. Then oil pollution claims. For that also, a certificate of the P&I club is important. Basically, a vessel cannot ply without a P&I insurance. In fact, a vessel is not allowed into the port without a P&I cover. So that is how important the P&I insurance is. If there is no P&I insurance, ships will not be able to ply, and international trade will come to a halt.
What are the major claims which P&I clubs deal with, and how do they deal with them?
Okay, so P&I clubs basically, as I already mentioned, the type of claims that they would deal with. So if there is a cargo dispute also, basically any liability related claims would be handled by P&I club. They have their own sets of rules as to what is admissible and what comes under their coverage, what may not come under their coverage. They have a very clear rules as to that. So, and how they deal with is, shipping is a very international business, where it is not necessary that the country of registration of the vessel is where all the disputes will happen. So you need correspondents all over the world who look after the business of the club. So these correspondents are based almost in all port cities, and they assist the P&I clubs in providing services to their members or the ship owners. Another actually point that I would like to highlight is that generally the idea is P&I clubs are only for ship owners, but now there are P&I clubs for intermediaries as well, for charterers as well. So there are clubs that cover charterers' liabilities along with ship owners' liabilities, and as well as other intermediaries. So that ways, so they would, in that sense, manage the disputes and the claims. They would assist the ship owners in appointing lawyers and handling the entire disputes for the ship owners. So they provide professional services in respect of liability management.
So, ma'am, you mentioned that there are a lot of parties nowadays, like intermediaries, charterers. So like international shipping regulations have become more and more complex. So are there any challenges that P&I clubs face, and if so, how do they deal with it?
Challenges that I see these days are mainly with respect to larger claims that come in. As I already told you, P&I insurance is where the ship owners themselves come together and insure each other. So when a larger claim comes in, then that would just drain the pool of resources that are available with a club. And incidents like say a huge oil pollution claim, or we've had these recent incidences where vessels have got stuck. These kind of incidences might affect the club's ability to cover. And it may not affect their ability, but what would happen is that the following year there would be a larger call or a larger premium that would be paid, but that would have to be paid by the members itself. So that is, I think that is the only difficulty that I see in respect of from the P&I angle, not otherwise.
What are the major types of shipping insurances that are available, and how do they help in mitigating the risk associated with charter or shipping industry?
Okay. So insurances, so you may bifurcate them into P&I insurance we've already covered. Then you also have something called as hull and machinery insurance that would actually insure the vessel itself and its machinery. Then you would have, and these all come under the aspect of marine insurance. You would also have cargo insurance. So there are various insurance policies that cover the cargo which is being transported from place A to place B. You also have shipbuilders policies. So when a vessel is being constructed, she is not yet a vessel. So those risks are also covered. Then you would also have freight insurances. You would have insurances covering stevedores, because their job is to load unload cargo. So they also face a lot of liabilities. So you have liability insurances for stevedores as well. So these are broadly the different kind of marine insurance policies that are available to various stakeholders.
So my question is, what do ship owners look for? What are the key considerations when they are going to select an insurance coverage?
Select an insurance company. So honestly, in India, so I'll only limit my answer to Indian ship owners, because in India, hull and machinery is primarily provided by the government-owned insurance companies like the New India Assurance, National Insurance, Oriental, and United. So mostly the ship owners, have their business, H&M business with these companies. You also have private players, no doubt, but major share of the market is captured by the Indian insurance companies. So what they look for is a greater coverage, providing them comprehensive coverage for all their liabilities. If there is a sue and labor claim, if there's a total loss claim, mainly a general average claim. So all those issues have to be, all those aspects have to be taken into consideration when you're negotiating with the insurance companies for your annual H&M plans.
And as you said that the disputes pertaining to insurance are dealt in consumer court, what are the types of disputes which arise related to marine insurance?
So not just Consumer Forum, that is one of the places where you can file your cases, but you can also file it in your regular courts as well. Kinds of disputes that you will find in marine insurance is primarily arising out of repudiation of the claims. So either the insurance company does not accept your claim, or they're only partially accepting your claim and repudiating the rest. So that is where your disputes arise, and eventually you make out a case as to why the repudiation is not correct on the part of the insurance company. Now, for example, if it's a repair claim, say a vessel is damaged and you have repaired the vessel. So what are the reasonable costs of repairs? So only the reasonable costs of repairs are covered, and that too where the damage is caused by a peril that is insured against. So you would have disputes where the insurance company would reject the claim, saying that sorry, this peril wasn't insured, or that your computation of your claim is not reasonable. So there may be also disputes where the sue and labor or general average contribution is not paid for by the insurance companies. These are the main kind of issues that are taken up from the ship owner's point of view that may arise. From cargo liability insurance, it's again the same, that there are three kinds of cargo insurance policies: ICC A, B, and C, and the coverage differs and all. So it may be possible that a certain the cause of a certain loss is not covered under a policy. So that may be a point of dispute that may arise under cargo insurance policies. So these are then taken up in court.
So, in your opinion, how is maritime legal practice different from other specific dispute-related practices?
Very different, because we have something called as the in rem jurisdiction. As I already mentioned before, that you have the Admiralty Act, which sets out a certain number of claims which are maritime claims. So the special thing about the Admiralty jurisdiction is that the ship itself is the juristic entity that you can proceed against. You can have your claim directly against the vessel. Of course, there are other rules that you need to look at, and you need to fall into that particular category. But this is the most special thing about the Admiralty jurisdiction, that you can proceed in rem against the ship itself. Your owner may not. Generally, the owners are not available in India. They're all foreign entities. So in that case, you file a claim directly against the vessel by arresting the vessel. And so she has to be within your territorial jurisdiction. That's when you enforce your action and you arrest the vessel, and you can get security for your claim. So I would say this is very important from litigation perspective, because generally you don't get security easily for your claim. So under the Admiralty jurisdiction, if once you prove that you have a maritime claim and it can be enforced against the vessel, the court grants you an order of arrest. And if the ship owner then wants to release his vessel, he needs to put up security for the claim. This is, of course, subject to final adjudication. But I think this is the most peculiar and interesting aspect of the Admiralty jurisdiction.
Ma'am, how do you perceive the current legislative and regulatory framework in Indian maritime sector?
That's actually undergoing a lot of change. We have in the recent 2 to 3 years, we've had new acts that have been enacted. Like we have the Major Port Authorities Act, which replaced the earlier Major Ports Act. We have the new Inland Vessels Act of 2021. Even the merchant shipping legislation is going to be revamped, and we will have the new Merchant Shipping Act. There is a proposed Carriage of Goods by Sea Act 2024 and Bills of Lading Act 2024. Now, for those two acts, I would say that it's actually old wine in a new bottle. Actually, not even that. It's just changing the label of the bottle. It's not doing much, unfortunately. We would have liked to see e-bills of lading, that is electronic bills of lading, which are so widely used already by the industry. So have some form of regulatory framework for these e-bills of lading, which is now already prevalent outside of India. Like UK has just enacted a law which gives statutory recognition to e-bills of lading. Even Singapore has one. There is an UNCITRAL model law also, which provides for transfer of electronic documents. So we were hoping that we come into at par with all the international standards, because this is already being used by the maritime stakeholders. So that would have given some form of legitimacy and guidelines and regulatory framework for the users in India. Then I think these are the major acts that have, these are the two proposed legislations. And of course, the biggest one would be the Merchant Shipping Act, which is also being revamped and will be enacted very soon. So we are hoping that now the changes that come with the legislations, they do bring India at par with the international standards and framework. Unfortunately, I don't see the Bills of Lading Act, Bills of Lading Bill or the Carriage of Goods 2024 doing that. But we are hoping the Merchant Shipping Act will be a different example that we can set.
Ma'am, how did you gain an interest in maritime law? Like, is it something you picked up, or like you want to know the story behind it?
Okay, my father is a master mariner, so I was always fascinated with everything related to the sea, and that's when I thought that this would be an interesting field to be in. Fortunately, I really liked it, and I pursued it, and I love the practice. So it's gone well that way. That something that I thought would be interesting turned out to be to my liking, and and the practice also is. I think it keeps you on your toes. It's very interesting. So I think that's how my story is proceeded.
Now, lastly, I would like to ask you: do you have any advice or any message for students who are trying to pursue maritime law?
Sure. So all the youngsters who want to specialize in maritime law, what I would suggest is that try to do different kinds of internships. Don't limit yourself only to maritime law, because it's important to understand general law, general litigation practices itself if you want to become a good maritime lawyer. So I would suggest you do a variety of internships. And within maritime law also, I would suggest that you intern with a shipping company, you intern with, say, a logistics related company, a chartering firm, you work with a litigation lawyer, who practices maritime law, so that you get a well-rounded understanding and feel of what it is like to be a maritime lawyer before you actually decide to be one. So I think that will be very helpful for any student in their future. And I think that will also help them become a better maritime lawyer.
Thank you, ma'am. A sincere thank you to our esteemed guest for sharing your valuable insights with us today. We thank you, Apurva, ma'am. Your expertise has greatly enriched our understanding of key issues in maritime law. This has been a very insightful session, and we look forward to the possibility of welcoming you back in the future.
Sure. Thank you so much. Thank you.